Sabi ng professor ko dati sa partnership law, isang bagay na hindi ko makakalimutan even now. The more basic a term is, the easier or the harder it is to define. Mga simpleng bagay na parang goes without saying with us. Basic concepts na we regularly take for granted. Sila yung napakahirap upuan at pag-isipan kung ano ba talaga ang ibig sabihin. Try defining life. Try defining love. Now try defining nothing. How do you define nothing? How can you place the concept of nothing in a box? Sabi nga ni Apolinario Mabini sa General Luna, as played by the great Epi Quizon, naranasan mo na bang hulihin ng hangin? A void contract is something like that, something close to that. It is one that vests no rights and creates no obligations. A void contract produces no legal effect at all. This is the Supreme Court's definition as propounded in its February 29, 2016 decision in the case of Fulido versus Greeley, GR number 215014. There are three types of void contracts. The first type is defined under Article 1318 of the new Civil Code. Contracts that are void for want or lack of any of the three essential requisites. So there is no consent, no valid consent, there is no object, there is no cause. So any combination of these three things, or actually kahit na isa lang ang wala, di ba? As long as one of the essential requisites is absent, there is the contract, the resulting contract, if any, is void. The second type of void contract is outlined in Article 1409, where the object or the cause or the purpose of the contract is contrary to law, morals, good customs, public order, or public policy. So for example, a contract, a contract for the purchase of high-powered weapons, the purpose of which is to stage an armed rebellion to overthrow the government. Diba? It is contrary to law, contrary to public order and public policy, for sure. That kind of contract is void. Of course, we have already tackled simulation, diba? Where the purported contract does not reflect the true intent of the parties. So if a contract is absolutely simulated, as in the parties really did not intend to be bound by a contract at all. So basically the contract is a sham. An absolutely simulated contract is also void. So that's type number 2. Now, other contracts, void contracts falling within type number 2 under Article 1409 are those contracts where the cause or the object did not exist at the time of the transaction. Diba? The object must exist, it must be licit, kung naalala pa ninyo. Diba? If there is no object, then the contract is void, of course. Also, contracts where the object is outside the commerce of man. A contract to sell the moon, of course, hindi yan pwede. That contract is also void. 1409 also covers contracts that contemplate an impossible service. A contract where the service required is to catch a falling star. That's impossible, of course, and therefore the contract is also void. Contracts where the intention of the parties relative to the principal object of the contract cannot be ascertained. Void contract din yan. And of course, contracts that are expressly prohibited by law. Like for example, a contract for the sale of illegal drugs. Of course, that's against the law. As a matter of fact, the illegal sale of dangerous drugs is prohibited and penalized under Section 5 of the Comprehensive Dangerous Drugs Act. So bawal, labag sa batas, void. Now, type number 3, defined in Article 1422 of the New Civil Code, pertaining to a contract which is the direct result of a previous illegal contract. Dito pumapasok yung maxim na the spring cannot rise higher than its source. Kung yung mother contract or the preceding contract is illegal, any contract arising from that is also illegal and therefore void. Now, can a void contract be ratified like the others? The answer, of course, is no. You cannot ratify nothing, di ba? A void contract does not produce any rights, does not impose any obligations. A void contract is essentially no contract. So, what contract is there to ratify? Wala, di ba? Void contracts cannot be ratified and neither can the right to set up the defense of illegality be waived. Now, bakit? You might be thinking, bakit hindi pa pwedeng i-ratify ang isang void contract? Like I said, a void contract does not exist in any legal contemplation. Again, naranasan mo na bang hulihin ng hangin? A void contract is nothing. It is a non-event, a non-entity. You cannot ratify or make valid something that does not even exist. That's the reason. Now, any party to a void contract or someone who seeks to enforce the void contract cannot claim that the other party has waived the defense of voidness. Diba? Doon sa ibang kontrata na napag-usapan natin, particularly sa unenforceable contracts, diba? Where the other party has already received benefits by virtue of the contract. Hindi na pwedeng erase yung matter of unenforceability or yung defense of unenforceability. Diba? Sa void contracts, hindi bebenta yun. Sa void contracts, walang ganon. Precisely because something that is illegal or something that is void does not cease to be void just because someone does not question it. When something doesn't exist, it doesn't exist. Hindi nag-iiba yung nature niya simply because the other party does not recognize that the contract is void. Now, is there a prescriptive period to file an action for the declaration of the nullity or voidness of a void contract? The answer is none. There is none. The action or defense for the declaration of the inexistence of a contract, it does not prescribe, pursuant to Article 1410 of the New Civil Code. Now, can third persons raise the defense of the illegality of a contract? Of course, the answer is no. Relativity of contracts pa rin ang applicable. The defense of illegality of contracts is not available to third persons whose interests are not directly affected. Okay? Siyempre, hindi rin available yung the usual remedies, no attachment of property, action pauliana, hindi sila applicable dito. Hindi sila available when the contract involved is a void contract. Now, we have previously discussed the matter of divisible and indivisible contracts. Just to refresh your memory, a contract is indivisible mostly because either the parties intended the contract to be indivisible or if the object itself of the contract is indivisible in nature. Like my usual example, a sports car. Hindi mo naman siya pwedeng i-deliver ng piece by piece, di ba? You deliver the entire car. On the other hand, we also have divisible contracts which pertain more often than not to agreements where the object or where the subject matter is divisible in nature. There are divisible contracts that are only partly void. So merong portions yung kontrata which can be set apart from the other parts, na yun lang yung void. The rest can subsist or can exist independently. No? If the illegal terms can be separated from the legal terms, then the legal terms may be enforced. Pwedeng the remainder of a divisible contract can be valid, whereas the other portion or portions can be struck down as void. Now, of course, diba, the presumption here would be that where there is doubt as to whether the terms of a contract are divisible or not, ang presumption is always in favor of divisibility. Actually, related to this, meron tayong tinatawag na mga separability clause sa karamihan sa mga kontrata in existence. Ang separability clause, ang silbi niyan is that in case merong clause, merong portion yung kontrata which is void or which is against the law, it will not cause the nullification of the rest of the provisions of the contract that are valid or lawful. Okay, of course, the exception here would be if the parties intended that the transaction or that the contract be indivisible. In which case, kung merong portion na void, then the entire contract will go down with it. Void talaga in its entirety. Now, when the nullity of the contract proceeds from the illegality of the cause or object and the act constitutes a criminal offense, kagaya nga nung sinabi ko kanina, illegal sale of dangerous drugs under Section 5, Article 2 of the Comprehensive Dangerous Drugs Act, where both parties are at fault. So merong talagang buyer, no? Merong buyer na hindi by bus operation as in literal na civilian na private individual na gustong bumili ng shabu. Tapos merong nagbebenta ng shabu. Where both parties are in pari delicto or where both parties are at fault, hindi sila pwedeng magkasuhan. No? The parties will have no cause of action against each other. The law will leave them where they are. Of course, dahil the act constitutes a criminal offense, both of them shall be prosecuted. Actually, ang pagbili nga ng illegal drugs, that's an entirely different offense, no? Iba pa yan doon sa pwedeng isampang kaso doon sa nagbebenta. Now, applicable provisions of our criminal law on the disposal of the proceeds or instruments or effects of a crime shall be applicable. So for example, no, yung shabu, meron niyang sinusunod na procedure for the destruction of drug evidence. So yung ibinentang droga, kukumpiskahin yan ng gobyerno at hindi itatapon not necessarily. They will be destroyed. So depende sa procedure. Pwedeng ililibing sila ng malalim sa lupa, yung iba sinusunog. Alright? Now, what if hindi sila in pari delicto? What if only one of the parties is guilty? Okay, for example, by bus operation. So yung bumibili ng droga, undercover police. So malamang sa malamang, hindi naman siya bumibili in order to further a criminal activity, but simply para mahuli, ma-entrap itong nagbebenta ng shabu. And therefore, hindi pwedeng kasuhan si mamang police ng violation ng Dangerous Drugs Act. Talagang si seller lang yung pwedeng sampahan ng asunto for illegal sale of dangerous drugs. Same din, of course, the proceeds of the crime as well as the drug evidence, they shall be disposed. Yung marked money, syempre, ibabalik yan, no? Ibabalik yan sa gobyerno. Now, the innocent party may claim what he has given and shall not be bound to comply with his promise. So, hindi pwedeng, for example, marked money nga, no? Hindi pwedeng sabihin ni seller na binigay mo na sa akin yung pera, sa akin yan. Hindi niya he cannot hold on to the money. Kailangan kunin yan, no? Kukumpiskahin niya ng hukuman at ibabalik sa pamahalaan kasi nga marked money yan, it's the government's money to begin with. Now, what if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense? Okay. Paano kung ganito ang sitwasyon? Now, where both of the parties are, well, in pari delicto sila, both are at fault, hindi nila pwedeng bawiin. There can be no restitution. There can be no action for specific performance. Wala, hindi pwede. But where only one party is at fault, yung party na may kasalanan, yung party na may mali, he or she cannot recover what he has given by reason of the contract. Yung innocent party lang yung pwedeng kumuha, no? Pwedeng mag-demand na ibalik sa kanya kung ano yung kanyang ibinigay. Practically the same rules din as the previous one. Now, what if the contract provides for the payment of interest? Well, interest paid in excess of the interest allowed by the usury laws may be recovered by the debtor. But here's the thing, as we have previously discussed, di ba? Hindi pa rin operative ang ating usury law. Suspended pa din siya ng Bangko Sentral. Now, what if money is paid or property is delivered for an illegal purpose? Okay? So basically, umorder ng mga baril. Ayun nga, ang purpose pala is para mag-rebellion at patalsikin ang mga nakaupo sa pamahalaan. The contract may be repudiated by one of the parties. No, pwedeng sabihin na hindi natin dapat ituloy itong kasunduan ito before the purpose has been accomplished. So, bago pa man magkaroon ng actual na pag-aaklas, pwedeng i-repudiate ng isa sa mga parties. Sabihin natin na nagkaroon ng change of heart yung isa sa mga parties to this contract. Nalaman kasi niya na yung purpose pala nung pag-acquire ng mga armas para sa illegal na layunin. Alright? Paano yun? So, nagbago yung isip nung seller. Pwede niyang i-repudiate yung agreement. Or, no, yun nga, hindi na niya kinakailangang maghintay na magkaroon ng actual na revolusyon. Before the purpose of the contract is accomplished, the contract may be repudiated. Of course, no, hindi niya rin kailangan maghintay bago may masaktan, diba? Before any damage has been caused to a third person. Now, no, the courts may, if public interest will thus be subserved, allow the repudiating party to dapat, to recover the money or property. So, pwedeng mangyari na the party who wishes to repudiate the contract, that party can go to court and then the court will direct na ibalik dito kay seller yung mga armas na dapat i-deliver. Pwede yon. Now, what if one of the parties to an illegal contract is incapable of giving consent? The courts in that case may, if the interest of justice demands it, allow the recovery of the money or property delivered by the incapacitated person. Basically, the same rules naman to. Same rules in play with regard to parties incapable of giving consent in general. Ganon-ganon pa rin naman. Now, what if the agreement is not illegal per se? No, ibig sabihin, hindi siya bad by its nature, hindi siya improper, hindi siya immoral or contrary to the conscience. The plaintiff, no, basically someone who files a case regarding this matter in court, the plaintiff may, if public policy is thereby enhanced, recover what he has paid or delivered. Now, what if the price of any article or commodity is determined by statute, by the law? Any person paying any amount in excess of the maximum price allowed may recover such excess. Yung hanggang doon lang sa ceiling na ini-impose ng batas, yung sobra, kailangan ibalik. Now, what if the law fixes or authorizes the fixing of maximum hours of labor and a laborer undertakes to work longer than the hours fixed? Diba? So a contract of labor, meron tayong sinusunod under our labor code na maximum work, maximum number of hours work, 8 hours. Okay? Pwedeng mas mababa sa 8 oras, pero ang maximum 8 oras. What if yung empleyado nagtrabaho ng lampas sa 8 oras? Does that have any effect as to the validity of the contract of employment? Actually, wala. No? What would happen here is that the laborer can demand additional pay for services rendered beyond the maximum number of working hours. Yun yung tinatawag natin, mga kaibigan, na overtime pay. Alright? Ngayon naman, minimum wage. Baka mamaya na napakinggan ninyo o napanood niyo sa telebisyon yung imposition ng updated daily minimum wage rate for NCR and I think for Western Visayas. The law sets or authorizes a particular minimum wage. Ngayon, marami mga unscrupulous na mga employer sa private sector na kahit na mayroong nakaset na minimum wage, mas mababa pa rin doon yung binibigay nila sa kanilang mga manggagawa. Ano ang karapatan ng laborer doon? Of course, the laborer shall be entitled to recover the deficiency. Kasi batas mismo yung nagbabandato, no? Na kailangan ang minimum na sweldo ng mga ganitong empleyado, this amount, up to this amount. Hindi pwede mas mababa yung makuha niya. The laborer will always be entitled to the excess. So up next, no, last one for the road, we will be talking about natural obligations. So see you in the next one.